Okay, so here is my final takeaways for employers. Keep your emotions in check. It's very hard once you know somebody has a substance abuse issue not to be concerned for the person, but also not to be concerned for your business. And you will view that person in a different lens. And I think you just have to make sure you're checking yourself once that information has been clear to you, that you're treating the person the same as you would anybody else. Be discreet. Who needs to know? Quickly, I'll talk about EAPs. You know, that's a complicated issue. If you have an in-house EAP, there's a whole bunch of confidentiality laws that potentially apply. Whether you have an employee sign a waiver, whether you have access to some of that EAP, Employee Assistance Program information, is a murky area of the law. I think in terms of EAP or not EAP, substance abuse, HR stuff should be kept separately and apart. Only who needs to know. That person's told you that they're an alcoholic. It shouldn't be in a general HR file where all HR staff would have the ability to see that. It shouldn't be told to managers. Who needs to know that so-and-so came to you to request a week off to go to rehab? Nobody needs to know that the person wasn't on vacation. I think it's a really important thing that you want to make sure you're not violating that person's privacy and also not finding yourself in hot water for disclosing personal information. Make sure you're consistent with all employees. Always give the employee a chance to be heard. You don't know why the drug test came back positive. Find out first. Write it all down as soon as it happens so that it can't later be said that you concocted it as an excuse for firing them for a discriminatory reason. And as always, consult an attorney. Do you guys have anything else to add on that?
I wanted to say about the be discreet part, that goes with the privacy piece as well. Because remember that the Bratt case says that, well, intra-corporate dissemination is a violation of privacy. The question is going to be then the balancing act. So yes, be very discreet and think about that balancing act before you actually disseminate. Because I wanted to point out that in Barbudo, the claim that went forward was the privacy claim. So these are potent claims, and especially where there's medical information, the SJC has recognized that that's inherently private. In Bratt, they found there was a counterweight to the balancing, but that, of course, means a lot of litigation and a lot of time in court when maybe a smarter decision up front could have foreclosed it. But those are potent claims. And what went with Bratt, which we didn't discuss today, was defamation claims. But some of these things we've talked about could also potentially be a defamation claim, which I've brought, I know other people have brought. So even if there isn't something said exactly, an employee who's escorted off the premises, such that people get an impression that they stole something or that they ripped off employee trade secrets or something.
Yeah, that can also apply to, and there's a case where, I don't know if it was an email or an internal email went out saying that such and such employee is not here anymore, but said some negative things about them.
Yeah.
In the email. And I believe the holding there was that that information did not need to be distributed to all those people.
Yeah, exactly.